Good morning, everyone. Welcome to the Judiciary Committee. My name is Carl Rhodes. I'm the chair of the committee. This Zoom meeting and YouTube live stream event will include two agendas for the Judiciary Committee this morning, the 9:30 hearing agenda and the 9:31 hearing agenda. If you're here for the 9:31 agenda, I'm going to do that one after the 9:30 agenda, and that may be a while, so just a heads up. Other members of the committee are Vice Chair Kyo Kalole, Senators Ocasio, Gabbard, Lee, Kim, and Favela. As noted, this hearing is being live streamed on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website, capitol.hawaii.gov, capitol.hawaii.gov, and capital with an O. In the unlikely event that we have to cancel the meeting because of a major technical problem, we will reconvene on Tuesday, the 22nd at 9:25 via video conference, and a public notice will be posted. For those testifying remotely, you'll be muted and video disabled until it's your turn to testify, and there is a 2-minute time limit on testimony. If there is a temporary technical glitch when you're testifying, we'll try to come back to you, but we do have your written testimony. If we can fix the glitch quickly, we'll come back to you. Otherwise, we may have to move on, but we do have your written testimony. I think that's it. Let's go ahead and get started on the 9:30 agenda. First up on the 9:30 agenda is SB 2147. SB 2147 extends by 1 month the deadline by which nomination papers for candidates for elective office shall be made available, and that would be just for this year. This is a response to the delays that we had with the census. First up on 47 is Scott Nago, Chief Election Officer. Good morning.
Good morning to office. Good morning to office. Stands on its written testimony with comments, and we'll be happy to answer any questions. Thank you.
Okay, great. Thank you. That's the only testifier we have on SB 2147. Members, any questions? I guess I have a question, Mr. Nago. So it looks like we won't need this. Is that your view of the situation?
Correct. So, yes, we're currently on target to begin candidate filing March 1st.
Okay, and if there turns out to be lawsuits, would it still be useful to have it around just in case?
It would depend on what they filed. I believe in 2011 they filed a restraining order to stop candidate filing. Okay,
so if they did that, then okay, that's good enough. Thank you. I appreciate it. Thanks for being here. Members, if there are no other questions for Mr. Nago. Oh yeah, Senator Lee, go ahead.
Oh, thanks. Just real quick, a little bit tangential, but around the country, do you have any idea offhand what the actual length of period is for candidate filing in general? Ours is, I think, 4 months or so.
It really varies depending on it varies depending on the time, and it varies depending on the requirements to run for office. I mean, the signature requirements are what's required to file. So there's not really an average that I can give you. It's just it's all over the place.
Is it typical that states where you have more signature requirements, like some have, I think, hundreds or thousands, have longer periods of time, and those with less have less?
So the harder you make it to get on the ballot by adding more signatures or less time to collect the signatures, the more you run into ballot access issues, so those states probably do have something like a write-in voting, because we have a small amount of signature requests and a greater amount of time. We don't have ballot access issues such as write-in voting or barriers to ballot access.
Okay, thank you, Chair.
Thank you. Any other questions? If not, thank you for being here, Mr. Nago. We'll move on to the next bill, which is SB 2300. This allows candidates seeking election to use campaign funds for child care and vital household dependent care costs under certain conditions. First up on SB 2300 is Gary Kam, General Counsel for the Campaign Spending Commission. Good morning, Mr. Kam.
Good morning, Chair, Vice Chair, members of the committee. I will stand on the Commission's written comments. Thank you.
Thank you. Next up is Carla Jabola Karoulis, Executive Director for Hawaii State Commission on the Status of Women.
Not present, Chair.
Thank you. She's in support. They're in support. Sandy Ma, Common Cause Hawaii.
Good morning, Chair,
Good morning.
Vice Chair. Good morning. Members of the committee, Sandy Ma for Common Cause Hawaii. We support SB 2300. We don't think that having to care for children or dependents should be a barrier to running for public office. This usually has a disproportionate impact on women and minorities. So we support SB 2300. I'm available to answer any questions. Thank you very much for hearing this bill. Thank you.
Thank you. Next up is Becky Gardner for Hawaii State Democratic Women's Caucus. Good morning.
Good morning. Aloha, Chair Rhodes, Vice Chair Keohokalole. I submitted the written testimony for the caucus, and I just want to call out some really sort of stark facts from it. Women are 15 times more likely to be responsible for the majority of childcare. So if we can just sort of establish that as a baseline expectation. And the history of this proposal, I think, is really interesting. It started back in 1995 when a US Republican Rep, Jim McCreary, had asked to use campaign funds for babysitting while his wife was joining him at campaign events. So that decision to allow such funds back in 1995, I think, was sort of the basis for the Federal Election Committee to approve a 2018 request by a federal candidate asking to use campaign funds for childcare. So that was the movement on the national level. Since then, 11 states have enacted state legislation to allow state candidates to use those funds in that way, and 14 others have introduced them. I think that Hawaii, it's really important. We sent Patsy Mink to DC, and I think Hawaii should be among one of the first to enact this on a state level. I also want to note that this is gender neutral. For example, Georgia Democrat Senator Raphael Warnock, he, a divorced father of two, he spent $39,000 in childcare expenses from campaign funds. So that's like a full-time job, really. And I guess I just want to say, I only have a few seconds left, is that we really should normalize this for all genders. For my own race, and I'll disclose, I ran for a House seat, and I was advised not to seek funds for childcare because it's a bad look. It looks frivolous. And that would just really hurt because it doesn't feel frivolous to me. So I had to like hide my responsibilities, and I don't think anyone should hide. And we need those people in office who understand what it's like to be responsible for domestic labor.
Thank you very much. Next up is Sarah Hogg for Vote Mama Foundation.
Hi, good morning. My name is Sarah Haig.
I'm sorry.
No worries. I'm the political director at Vote Mama Foundation. I'm here to speak on behalf of the organization in strong support of Senate Bill 2300. In 2018, Vote Mama Foundation founder and CEO Luba Gretchen Shirley ran for Congress when her kids were 1 and 3. She petitioned the Federal Election Commission and became the first woman to receive federal approval to use her campaign funds on childcare. This groundbreaking decision was approved by a unanimous bipartisan vote. Over 50 federal candidates have since used their campaign funds on childcare, both moms and dads, Democrats, Republicans, House candidates, Senate candidates, and even presidential candidates. However, the ruling does not apply to state and local candidates. Vote Mama Foundation is the only organization working with legislators across the country to introduce legislation to use campaign funds for childcare and dependent care by state and local candidates. We know that the first step to empowering a diverse pipeline of working caregivers to run for office is for candidates to no longer have to consider the cost of dependent care in weighing their decision to run. I think we can all agree our country needs working and middle class representation now more than ever, and campaign funds for dependent care breaks down a critical economic barrier to working caregivers running for office. 15 states have now passed legislation allowing the use of campaign funds for childcare. Vote Mama Foundation hopes Hawaii will become the 16th state. Hawaii is actually among 14 states this year that have introduced similar legislation. We are so grateful to Senator Kim for her leadership on this legislation, and we urge the committee to support Senate Bill 2300. Thank you so much.
Thank you very much. Next is Jasmine Slovak, founder of Great Wahine Run. Good morning.
Aloha, good morning, Chair Rhodes and Vice Chair Keohokalole and members of the Senate Judiciary Committee. My name is Jasmine Slovak. I represent Great Wahine Run. We stand on our testimony in support of SB 2300, largely for reasons that you've already heard. This aligns us with the Federal Elections Commission's rulings, as well as codifies and protects our candidates here in Hawaii. I think it acknowledges the economic situations and cultural situations of multi-generational living here in Hawaii. We often not only care for our keiki, but our kupuna. So many families and candidates have to make that choice between, do I continue to run for office and serve the public, or do I stand up and carry my family duties? You as members of the Senate know better than most that running for office is a full-time job without pay. And we as Hawaii citizens should not have to continue to bear the opportunity cost of viable candidates with families and family duties not running for office. Mahalo for letting me testify today.
Thank you very much. That's all the testifiers who signed up for Zoom. Next, we have Brent Colbus for the Honolulu County Republican Party in opposition. Gary Hoosier for Pono Hawaii Initiative in support. Rosemary Muller, AAUW of Hawaii in support. Kathleen Allgaier, Hawaii Children's Action Network Speaks in support. Then we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 4, 5, 6, 7, 8, 9, 10, 11. It's like 12, 11 in support and 1 in opposition. Okay, members, any questions? Senator Kim, go ahead.
I would just want to make a comment. I want to thank everyone for their coming out and testifying on this measure. I know when I first introduced it, we didn't have very many people. So it's good to see. When I ran for office, of course, I didn't have a kid. I wasn't married and I got pregnant and I had the baby while I was on the city council. Luckily, I had my parents there and they helped me care for my son. If it wasn't for them, I probably wouldn't have been able to continue on. And so now my son is 32 years old. But so while it certainly didn't benefit me, I hope that it will benefit other candidates or other people deciding to run. So thank you.
Thank you very much. Members, any other questions? I don't either. Let's go ahead and move on to the next bill. Thank you all of you for coming to testify today. Next up is SB 2331. This expands the definition of beer to specify an alcohol by volume of no less than 0.5% and to include alcohol seltzer beverages. First up on 2331 is Isaac Choi, Director, Department of Taxation, or his designee. Good morning.
Good morning, Chair, Vice Chair, members. Josh Michaels on behalf of the Director. The Department will stand on its testimony, offering comments. I'm happy to answer any questions. Thank you very much.
Thank you. Next up is Tom Yamachika for the Tax Foundation of Hawaii.
Good morning, Chair, members of the committee. This is Jade McMillan on behalf of Tom Yamashika and the Tax Foundation. We will stand on our written comments submitted on this measure. Thank you.
Thank you very much. Other testifiers in writing were Lanikai Brewing Company, Steve Holmschild, its CEO and founder, Garrett Marrero, CEO and founder for Maui Brewing Company, Pamela Tumpap for President for Maui Chamber of Commerce, all in support. Okay, members, any questions on SB 2331? Okay, I don't have any either. Let's go ahead and move on to SB 2082. 2082 adds abuse of family or household member to those felonies that qualify for repeat offender sentencing. First up on 2082 is Brandon Nakasato, Captain Criminal Investigation Division for the Honolulu Police Department.
Not present, Chair.
Present in support, Timothy Tate, Deputy Attorney General, Attorney General's Office. Good morning.
Chair and members of the committee. Deputy Attorney General Timothy Tate testifying on behalf of the department. And the department is in support of this bill, which would promote greater protection for victims of domestic violence and safety in the home. My other points are noted in my written testimony, and I'm available for any questions. Thank you.
Thank you very much. Next is Tricia Nakamatsu for the Department of the Prosecuting Attorney, City and County.
Not present, Chair.
In support. And Dara Carlin in support. That's all the testimony we have on SB 2082. Members, questions? For the Attorney General, please. So it's my understanding that this is one of the few crimes of violence that's not on the repeat. You can't get, I'm sorry, it doesn't have repeat offender sentencing options.
That's correct. This was not actually a statute at the time the repeat offender statute was enacted in 1976. It was a law that came into effect years later, and it has never been added to the repeat offender statute, and this amendment would allow that to happen.
Okay, great. Thank you. Any other questions, members? If not, thank you, Mr. Tate, for being here, and we'll go ahead and move on to the next bill, which is SB 2094. This amends prohibitions against certain individuals possessing or owning firearms to clarify that all individuals charged with a felony offense or convicted of certain offenses are prohibited from possessing a firearm. On 2094, first up, we have Tricia Nakamatsu, Deputy Prosecuting Attorney for the City and County of Honolulu.
Not present, Chair.
They're in support, and Gerard Silva is in opposition. There are 1, 2, 3, 4, 5, 6, 7 individuals, 6 in support and 1 in opposition. I guess there's no one to ask questions of on that one, so we'll go ahead and move on to the next bill, SB 2642. This establishes an exemption for mediation in paternity proceedings where there are allegations of domestic abuse, and amends the exemption for mediation in divorce proceedings by disallowing mediation when there are allegations of domestic violence. First up on SB 2642 is Judge Jesse Hall or Judge Matthew Viola.
Good morning.
Judge Hall. Good morning.
Good morning, Chair Rhodes, Vice Chair Keoho Kalole, and members of the committee. The family court stands on its testimony as written, and we're available for any questions. Thank you.
Thank you. Next up is Nancy Creedman for the Domestic Violence Action Center. Good morning.
Morning, committee chairs. We would like to see this bill enacted into law. Domestic Violence Action Center represents survivors in divorce and paternity cases. In divorce cases, there's a waiver of the court's order to mediation. The circumstances are very similar in paternity cases, except for involving domestic violence, except for the parties are not married. So it makes perfect sense for a similar exemption to be put in place to align the two statutes. So we would appreciate your consideration and your favorable action on it. I'm available, of course, to answer any questions you might have.
Great, thank you. Next is Debbie Shimizu for Hawaii State Democratic Women's Caucus in support, Dara Carlin in support, and Amy Chong in support. That's all the testimony we have on SB 2642. Members, any questions? Senator Casio, go ahead.
Thank you, Chair. I have questions for the judiciary.
Yes, Senator.
Aloha, thank you. I'm wondering what domestic violence training do family court judges currently receive, and also if there is a training, if there's a requirement for this training?
We do have mandatory training on a yearly basis. Actually, we have several, at least a few over the year, each year on domestic violence. It's one of the most trained topics for our judges. I'm sorry, ma'am.
And it's mandatory?
It is mandatory for our judges to attend, yes.
Okay, thank you, Jeff.
Thank you.
Okay, members, any other questions? If not, I have one from Ms. Creedman. So it sounds like, I mean, this bill actually, as it's written, I think, if I'm understanding correctly, it says no mediation at all in these situations. But it sounded to me like what you were saying was you would like the the system for mediation and paternity proceedings to be the same as it is in divorce where there are allegations of domestic violence. Am I hearing your testimony correctly, or do you think that there just shouldn't be any mediation whatsoever?
Well, I appreciate the question. We prefer that there not be mediation ordered. Of course, we support survivor autonomy, and if a survivor feels as though mediation is a viable option for her or him, that certainly should be the party's right to select. The problem, of course, is that judges will assume mediation is the perfect way to resolve conflicts. Of course, when there's domestic violence, it's not the perfect way to resolve conflicts. We support and we stand by the survivors as they're going through this process in court, and would sort of explore the issue with them and explain why mediation may not be the perfect vehicle for resolution of the issues. So we would just want to make sure that the courts are given the opportunity for there to be a waiver of the requirement to send everybody to mediation.
Okay, so and correct me if I'm wrong, because I don't practice law at all right now, and I never practiced. Well, I have been in family court once or twice, but you would like the paternity proceedings to be the same as the ones that are currently available in divorce proceedings, or is that not an accurate statement?
In the divorce statute, there's a waiver, there's an exemption to the
and you would like that to apply
Correct.
to the
Correct.
paternity actions too.
Yeah.
Okay.
Yeah.
Okay. Understood.
Okay, good, thanks.
Other questions? I think that was all I had. For Judge Hall, if you don't mind.
Yes, Senator.
So how does it work when currently in the divorce proceedings?
Well, currently the way the statute is.
Sorry, I hadn't quite formed it.
I'm
was
sorry.
thinking about my question. Sorry. What's the what do you do for divorce proceedings to screen for DV?
There are in our motions for pre and post decree relief, there is a box that parties may check off stating that there is domestic violence. Also, if there is an order for protection or a petition for a temporary restraining order that has been filed, we are notified of that case if a divorce case is coming before us. So we will have the restraining order file, as well as the divorce file before us when we're having the hearing.
Okay, so self-reporting, and then whatever the I guess it would be a TRO history, if there's a crime, a criminal history.
Correct.
Okay, thank you.
Thank you.
Members, any other questions? Okay, I think that's it for me on that one. Hang on just 1 second. Yeah, okay. Well, let's go ahead and move on to the next bill. This is SB 2660. This is relating to prostitution, allows defendants who entered deferred acceptance of nolo contender pleas to have the conviction vacated if conditions are met. First on 2660 is Lee Hayakawa for the Office of Public Defender.
Good morning.
Good morning.
Chair, Vice Chair, members of the committee. I'm Assistant Public Defender Lee Hayakawa. The Office of the Public Defender has submitted commentary on this measure. We will stand on our written testimony, and I am available for questions. Thank you.
Okay, thank you. Next is Cara Tang for the Legal Clinic. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair, members of the committee. My name is Cara Tang, and I'm an immigration staff attorney at the Legal Clinic. The Legal Clinic is a nonprofit organization that provides pro bono legal services to low-income immigrants in Hawaii. Part of our services that we provide is removal defense, which is also called deportation defense, which means that we represent immigrants and defend them in immigration court and prevent them from getting deported. When an immigrant is convicted of a crime within the United States, they are then placed into removal proceedings, and then we defend them. Part of our defense strategy can sometimes entail looking at their underlying criminal case, analyzing it, and applying for post-conviction relief, like vacatures, like HRS 712-12096. However, we've noticed with some of our clients that this vacatur excludes some of our clients. So currently HRS 712-12096 allows people who have been convicted of prostitution in the state of Hawaii to vacate their conviction if they have not reoffended within 3 years. And so we could theoretically apply for that vacatur. However, HRS 712-12096 fails to address certain defendants that take a certain type of plea. And it can be very technical, even for attorneys, especially for non-attorneys. And I have detailed this issue in our written pleadings and proposed amendments. So I won't go into it, but I am available for questions about it later. But essentially what we're seeking, we agree with the public defender's assessment on how the current SB 2660 was worded, and we've addressed those concerns in our proposed amendments. The bottom line is that the way that HRS 712-12096 is written right now, it actually excludes immigrant.
Thank you very much. We probably will have questions for you, but your 2 minutes is up. Next is Gerard Silva, who's in opposition, Dara Carlin in support, Cara Jabola Karulis for the Hawaii State Commission on the Status of Women in support, Carrie Ann Shirota for ACLU of Hawaii also in support. That's all the testimony we have on this measure. Members, any questions? Can I have both Ms. Tang and, sorry, who was up here? Mr. Hayakawa come on at the same time here? So what's not clear to me at this point is, I think I understand what the public defender is saying, which is if your guilty plea or your null contender plea are deferred, which is made by motion, then you never get and you follow the terms of the order, you never get a conviction.
That's correct, Senator.
So then there's nothing to vacate.
Right.
Correct.
So,
and we've addressed that in our proposed amendments. We do not agree with the way that it's currently worded. We agree with the public defenders that when you take a deferred acceptance of a nolo contendere plea, you comply with the terms of the court, or you don't comply with the terms of the court, then your plea is accepted and there is a conviction. And so to add that language as that is already redundant because the initial vacatur statute vacates convictions. What we're seeking to do is include people who received a deferred acceptance of a no contest or guilty plea, complied with the terms of the court, got their plea dismissed and expunged, because in the immigration context, that is still considered a conviction.
Is it expunged, or you can still see it on their record though? Either one of you, you can still see a DAG or a DANK that's been fulfilled, that the defendant fulfilled the terms of the court's order. That still shows up somewhere.
Yeah, it shows up to the U.S. ICE officials are able to still see it.
So where is it? I mean, does the state keep a record of it?
I'm unsure how they send that information to ICE.
Do you know, Mr. Hayakawa?
The process after your deferral is done or concluded, you have to wait another year, and then you can petition through the Attorney General's office to have your arrest record expunged. And once that's done, then nothing should appear regarding your criminal contact with the law.
So okay, so Ms. Tang, why isn't that expungement acceptable? I mean, it's gone.
Right, in immigration law.
You've never been convicted and it's gone.
Correct. In the criminal context, what you're saying is correct, but actually immigration law only recognizes vacatures, not expungements. And so it still exists as a conviction in immigration law because there are two elements to a conviction in immigration law. One, you need either a no contest or a guilty plea. And then two, the judge has to sentence you to some form of punishment or penalty. And doing a dank or a dag, you have to pay a fine, and you also have to fulfill terms of the court, sometimes community service. So within the immigration court context, they have found dank and dags to still constitute convictions. And the only way to get it off your record is to vacate it, not expunge it.
But there's nothing to vacate.
We're asking that we include in the language a vacation of the plea.
Mr. Hawai'i, do you have any idea whether that's possible?
I think it could be tailored such that it would allow for vacatur of that plea also.
Okay. All right. But so what you're really after is the vacation, the vacation of the plea itself, not anything following that, which you can already get rid of.
Correct. Well, I think there's a discrepancy. So in the criminal context, we could call it vacating the plea, but in the immigration context, it would still be considered vacation of the conviction.
Well, see, that's where I'm not sure I'm following you, because there's no conviction.
But there is in the immigration court.
We're not Congress. We're just the state. All we can do is control this. We can't even really control the state. We can influence what the state is doing. But, you know, if on the state record it's expunged and there's no conviction, from the state's perspective, there's nothing else we can do. If the feds want to do something else, I'm not sure there's anything we can do about that.
I understand what you're saying. I think we've included the amendments in our written testimony. I think they address your concerns. I think it should be worded vacation of the plea in the statute.
Okay, so you want to vacate the plea?
Yes.
All right. Well, we'll try. Okay. Anyone else on this one? If not, thank you both for being here, and we'll go ahead and move on to the next bill. Thank you. SB 2687 relating to criminal procedure. This specifies under the Hawaii Rules of Evidence, the court may order that the testimony of a witness be taken through a live two-way video connection in certain circumstances. First up on SB 2687 is Corey Young, Deputy Attorney General.
Good morning, Chair.
Good morning.
Committee. I'm Corey Young, speaking on behalf of the department. We did offer some technical comments on the bill, but our main concern was that basically, as written, it would unilaterally allow the defense to essentially provide this video testimony. We are asking that it be by agreement of both parties, both the prosecution and the defense would agree before video testimony would be taken, or the court could make its finding of necessity. We understand the concerns by the Public Defender's Office that, you know, that's going to be a very high standard, and their concerns about constitutional confrontation, and it's valid. You know, these are going to be very rare cases where a court is going to be able to essentially take the video if there is no consent by the defense, but that doesn't mean that it's not a tool that the legislature should put in the court's toolbox. This is going to be a situation where, you know, it's an evolving area of technology, and our ability to police it is going to evolve, and the courts are going to be a part of that. So I'm going to be available for any questions, and I thank the committee for this opportunity to address you.
Thank you very much. Next up is James Tabe, Office of Public Defender. Good morning.
Hey, good morning, Chair. Good morning, Vice Chair. Good morning, members of the committee. This is James Tabe with the Public Defender's Office. We will stand on our testimony in opposition. I do want to make a few comments here. First, I think any attempt to apply this law is going to be found unconstitutional. One, the confrontation clause is, we equate it as face-to-face. I don't think there's no substitute to face-to-face testimony. There's also a problem with the prior fact. Prior fact should be that witnesses should be face-to-face with the prior fact, especially with jury. They have to judge credibility, which includes demeanor, appearance. We don't think, next, look at my time here, good. The safeguards that are built into this bill here, it's so impractical. Number one, it's if you're going to have the attorney stay with the witness, then the attorney's not going to be with the defendant. And the defendant has a right to have his attorney next to him to confer. I think it's detailed in my written testimony. And as well as the practical effect is that we're going to have to take a recess trial, and I mean a several-day recess in the middle of the trial for the attorney to travel to wherever the witness is, and obviously for the trial, the testimony, and to come back. So that's a very impractical safeguard. I do know that, I don't know if the judiciary has a representative here testify, but I would urge the committee to read and respect the judiciary's testimony. That committee, the evidence committee, includes some of the finest evidence code minds in our state, Addison Bowman, Professor Barkey, Phil Lowenthal, Judy Pavey, and I think a lot of weight to be given to their testimony. Thank you.
Thank you very much. Next, we have Catherine Remigio, Judge Remigio for the judiciary, not here on Zoom, but in opposition. Okay, that's all the testimony we have on SB 2687. Members, any questions? I don't think I have any either. Let's go ahead and thank you very much for being here, testifiers, and we'll go ahead and move on to the next bill, which is SB 2741, relating to the Commission to Promote Uniform Legislation. Provides a limited exemption for the Hawaii Commission to promote uniform legislation from certain requirements of Part 1 of Chapter 92 for the purpose of allowing commissioners of the Commission to promote uniform legislation to attend and participate in a full capacity in meetings hosted by the Uniform Law Commission. Okay, first up on 2741 is Stella Cam, Deputy Attorney General.
Good morning, Chair, Vice Chair, members of the committee. Stella Cam on behalf of the Department of the Attorney General. We are in strong support of this bill for the reasons stated in my written testimony, and I'm available for any questions if you have them. Thank you.
Okay, thank you. Next is Blake Oshiro, member of the CPUL. Good morning.
Morning, Chair, Vice Chair, members of the committee. Blake Oshiro here in my individual capacity as a member of the commission. We are in support of this legislation, and I will stand on my written and be available for any questions. Thank you.
Thank you very much. Next is Lonnie Ewert. Let's see here. Oh, there you are.
Good morning, Chair, members of the committee. I'm the chair and also a member of the Commission to Promote Uniform Legislation. I'm in support of this. I have submitted written testimony, which I will just stand on, and I'm available for any questions. Thank you.
Thank you very much. Thanks for being here. Next is Cheryl Kakazu Park for Director of the Office of Information Practices with comments. Sandy Ma, Executive Director for Common Cause Hawaii with comments. Elizabeth Kent, member of the CPUL in support. Ken Takayama, member of Uniform Law Commission in support. Peter Hamasaki in support, and Kevin Sumida in support. That's all the testimony we have on SB 2741. Members, questions? I'm okay on this one too. Let's go ahead and move on. Thank you for being here to testify. Next bill is SB 2747. This is relating to the Uniform Parentage Act. Repeals and replaces the Uniform Parentage Act of 1973 with the Uniform Parentage Act of 2017. First up on 2747 is Judge Hall or Judge Viola. Judge Hall, morning again.
Good morning again, Chair Rhodes, Vice Chair Ko'oho Kalole, and members of the committee. I won't restate what is in our written testimony, but I would like to reinforce the fact that Hawaii Vice Statutes Chapter 584 is in need of updating. We're doing a disservice to our community at large, relying on this outdated version, and I'm available for any questions. Thank you.
Thank you. Next up is Mark Nugent, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, and committee members. This is Mark Nugent, Deputy Attorney General. The department supports the bill, but has offered written testimony with some specific changes to sections of the bill. Basically, those changes are recommended to ensure consistency between the model UPA existing Hawaii revised statute or Hawaii law and federal laws. I'm available for questions if you have any. Thank you.
Thank you. Next is Michael Galoyo Jr. for the Stonewall Caucus Democratic Party of Hawaii.
Not present, Chair.
In support, next is Kat McGlone.
Not present, Chair.
In opposition, written testimony includes Elizabeth Kent for the Commission to Promote Uniform Laws. Wendy Kramer for Donor Sibling Registry with comments. Mihoko Oto for Hawaii Women Lawyers in support. Neil Holbert for Truth and Adoption in opposition. Eileen McKee in support. Mark Shapiro in opposition. Bethany Murray in opposition. Jory Nakamine with comments. Aaron Castillo in opposition. Jay Takane in opposition. And Carol Lockwood in support. That's all the testimony we have on SB 2747. Members, questions?
Chair, Ms. Carol Lockwood would like to testify. She
Okay,
signed up
yeah,
with-
okay, sure, go ahead. Good morning.
Aloha, Chair Rhodes, Vice Chair Keoho Kalole, and the members of the committee. My name is Carol Lockwood. I'm an attorney in private practice here in Honolulu, and I'm Hawaii's only member of the American Academy of Adoption and Assisted Reproductive Technology Attorneys. I submitted written testimony overnight. I apologize it was late, but welcome this opportunity to address you briefly in person. I've been practicing in the field of assisted reproductive technology law for more than a dozen years, and I've had the privilege of helping hundreds of infertile LGBTQ and non-cis heteronormative individuals and couples create or expand their families through the use of assisted reproductive technology, including sperm, ova, and embryo donation, reciprocal IVF, and gestational surrogacy. As described in my written testimony, I witnessed firsthand the many challenges that these families encounter, legal, financial, practical, and even emotional, in attempting to confirm their legal status, rights, and responsibilities as their child's legal parents. I described briefly in my written testimony some of the important ways SB 2747 would alleviate these challenges. What I'd like to emphasize to you in person is that with or without SB 2747, these individuals and couples exist and they are creating their families through assisted reproductive technology. What is happening, however, is they're being forced to do so in a vacuum without the support, guidance, and structure of directly applicable laws. Yes, we find a way to help them using a patchwork of existing statutes and with the help of a family court that has been very supportive of Hawaii's traditionally broad definition of ohana. But it's a little like trying to bake a cake with nothing but chopsticks, a skillet, and a campfire. With enough time and effort, you can get the job done, but it's a lot harder and messier than it needs to be. These situations are not theoretical. They're occurring every day, and they're hurting some of the most responsible and loving parents and would-be parents in our state. So I'm respectfully asking you to please pass SB 2747 out of committee. We can kick this can down the road another year or two, but it won't stop the use of assisted reproductive technology or the creation of these loving families. It will simply force Hawaii's infertile, LGBTQ+ and non-cis heteronormative families to continue to endure unequal treatment, to pursue parenthood without your valuable guidance, and to proceed without your protection. They deserve better than that from all of us. I'm happy to answer any questions you might have, and I thank you for your time.
Thank you. Let's see. Okay, so members, any questions on SB 2747? I think I saw some hand. Okay, first of all, with Senator Lee, followed by Senator Ocasio. Go ahead, Senator Lee.
Oh, thanks. For either the AG or judiciary, I guess. Right now, the law, as I understand it, allows someone who's adopted or in a similar situation, once they turn 18, to access what would otherwise be sealed records identifying their parents. Is that right?
Correct.
And would this bill change that in its current form?
No, we would not be changing the adoption statute at all.
In other words, you could still access, upon turning 18, you'd still be able to access those records, even if those were kept sealed. Is that right?
If you're talking about adoption records, yes, that is correct. We're not changing that provision.
Okay. But then for the genetic, forgive me, I'm not familiar with the terminology.
Surrogacy, are you thinking of?
Not so much surrogacy, but
Donor conceived.
yes, thank you. I'm not I'm not a father right now, so I haven't gone through this. But in that situation, when that individual who's born out of that situation turns 18, is it the same thing where they would still be able to access their biological parental information and identify who those people are?
No, and currently they're not able to. If a family uses a sperm donor, for example, part of the contract of the sperm donor is they stay anonymous. So they, even to today, they do not have access to that information. There would be a lot of concern for donors to assist if their anonymity was not kept.
Are there other places that allow for only those donors that do allow their information to be made available down the road?
I'm not aware. I'm not sure.
Okay. I raised this only because, so I'm adopted, and I had no idea who my biological parents were until we changed the law to allow that information to become accessible, which for me was like a kind of a huge deal in many ways, being able to get a sense of where you're at. I think, I'm not sure there's a difference between being adopted versus being born, through these other methods, in terms of like the psychological effect that can have on you growing up. So was there discussion about applying the adoption law across the board to those born of donors as well?
There was a task force that was created recently, and last legislative session, excuse me. And we had not gotten deep into that conversation yet. Unfortunately, we ran out of time before we could get into that conversation. I did see Ms. Lockwood had her hand raised though on that issue.
Sure, go ahead, Ms. Lockwood.
I'm sorry, if I can answer with a little bit of practical experience.
Yeah, go ahead.
As a practical information, I handle both adoption and assisted reproductive technology. The level of information that's available on adoptive parents depends a lot on the cooperation and availability of the adoptive parents. So even with access to the records, it's often a very superficial level of information that's available in terms of medical background. Even in Hawaii, we have a very basic form and people check a box whether or not something applied within certain generations. And sometimes they just draw a line down the no and they don't get into a lot of detail. In contrast, in assisted reproductive technology, you can get up to 75 pages of information on the genetic and medical background of the donors. They're screened very selectively and go through a lot of testing. And so as a practical matter, a lot of donor conceived children know more about their medical and genetic history and background than children born to natural families and especially adopted children. So it's less of an obstacle than you might think as a practical matter because they go through all this screening. If you think of all the people who have children, for instance, through one-night stands, or who, God forbid, lose a parent, or whose parents are estranged and don't communicate effectively, my personal opinion is we should not impose a burden on donor-conceived children that we do not impose on any other children in the society. And saying a child should not exist unless they have a detailed access or access to detailed medical and genetic information, that would preclude the existence of a lot of children, whether adoptive, whether natural born, or whether born through assisted reproductive technology. It's a very high standard.
I appreciate that. I think, my question wasn't so much about the medical history and everything else and that, although I'm familiar with that too, because I've had some medical issues in the past and had no idea what that genetic history was because I had no idea where I came from. But just knowing who those people are, I think is what I'm getting at, which has at least for me and some of the people that I've known who have been in my position that we've worked with over the years, that's a profound psychological, developmental worldview shift. And to not have access to that, I think.
Of course. Yeah, it still occurs naturally, but with one-night stands and things, unfortunately. But I agree that it is obviously a factor that needs to be considered. The good news is, as I encourage my clients, in this time of recreational genetic testing, there's no reason not to be completely open with your children about their origins and to share any and all information you have, because the odds are they're going to find it out for themselves anyway.
Thanks. So just back to Ms. Hall real quick, and Chair, this is my last question, and thank you for your indulgence. Were we to say that only only those embryos or whatever it was that are taken from folks who have acknowledged that they are willing to make their identities known, 18 years down the road. Would you guys, would it make sense to, or would you be open to putting that in the law so that regardless of situation, that option does exist for those people who are born of these methods?
I would not be opposed to furthering the discussion because I'm sure there's others that, like the parents to be, may not necessarily want that information out. So I'd like to hear both sides before I completely say that whether I'm opposed or not opposed to it.
Well, I guess we're sort of in a situation where we're changing the law right now. So
Understood.
There isn't really so much time for more discussion unless we sort of leave the bill and come back to it next year. But how is it? Well, I think I've made my point. So thank you, Chair. I won't belabor it. I appreciate both your comments. Thank you very much.
Before I go to Senator Ocasio, one of the testifiers who had signed up for Zoom is here now. So I'm going to go ahead and let her testify. Kat McGlona, if you're still here, go ahead. No.
Hi.
There you are. Okay, go ahead.
I wanted to set my timer so I can keep track here. Thank you so much. Aloha. I grew up not knowing anything about my ethnicity, my birth family, and I know what it feels like to experience a fog about this basic elements of my identity. And I know it may be hard to understand for those of you who always grew up knowing your families. As an adult, I uncovered big secrets that were withheld from me and my family. And it wasn't healthy for anybody that was involved with these secrets. At the time, it was in the 1950s. And so it can be explained, oh, there was a lot of stigma for, an unmarried woman getting pregnant then. But we know more now. So my question is, why is the state of Hawaii putting into a law that it would be okay for a class of people to be forever denied from knowing the basic knowledge of where their genetic material that they were created from came from? And we know it's important for humans for their well-being to have this information. So I'm saying like, hey, do we really want the state to participate in keeping secret from these adults? And the babies that are created through assisted reproduction do grow up to be adults. And my written testimony includes some ideas for how we can amend the bill to strengthen it to protect these offspring. One is to only use gametes that come from Hawaii. To only use gametes in Hawaii that come from people that are willing to have their to be identified. And also to officially document somehow the ID number of this donation and what gamete bank they came from, because apparently their records aren't always kept in the family, and these offspring often don't know where they came from. So to have an official documentation somehow associated with the birth certificate. So we have evidence that it is important for humans to know the truth about their origins and to feel connected to their roots. So thank you for the opportunity to testify.
Thank you. We'll return to questioning. I think Senator Ocasio had the next question. Go ahead.
Thank you, Chair. No, my question is along the same lines as Senator Lee, and it's for the judiciary. So in hearing also the previous testifier, how do we balance these competing rights, especially the right to information by donor conceived persons, and adoptees, but also especially in regard to these important medical histories. And so that's the sticking part, I think, for me. So if you can comment on that.
As Ms. Lockwood had stated, the medical histories information is there and it's much more extensive. As I said, I'm not opposed to making amendments to include a provision for that. I haven't seen the proposed language that our previous testifier has included that could solve all the problems. But that's why I'm just hesitant on saying whether or not we should or should not. I just would like to see the language first.
Yeah, thank you. Thank you, Chair.
Okay. Any members, any other questions? If not, I have one for Judge Hall as well. As you alluded to, there was a task force set up. I guess it was last session that was meeting and discussing and some of the important questions in the new Parentage Act. But I think it was fairly severely impeded by the pandemic, and there were a lot of in their report, it seemed to me that there was a lot of questions that were not really answered one way or the other. Do you really think the bill is ready to go with that many outstanding issues?
I had hoped that the task force, we would have had more time. It wasn't only the pandemic. Unfortunately, Department of Health also had to deal with the Red Hill water crisis in the midst of us trying to have our discussions also. So I do think, to be honest with you, I do think the bill is ready to go, but I also understand if further discussion is necessary.
Okay. Okay, thank you. Members, any other questions? Senator Costa.
I do have actually for Ms. McGowan, can you speak to the availability of DNA data in terms of, you mentioned it also in your testimony?
Sorry, excuse me. Yes. So with DNA tests being so affordable and available and publicized, a lot of people turn to DNA to find out they're trying to reach family members. And to say that you can, in the day of DNA, that a donor can remain anonymous forever is unrealistic. But it's a clunky way to have people like match with the donor's mother or the donor's children or the donor's siblings or cousins, and then they try to figure out how they're all related. So with the DNA, people do have some mechanism of finding out family, but it's not as private as if they just had the information recorded and could get it, in that manner. And also the main thing that happens when a donor conceived people do DNA is they find out they have a lot of siblings. The highest I've heard was like 200 some, but it's not at all uncommon to find out they have 10, 15, 30, 50, 70 siblings. So, I mean, the industry is basically pretty unregulated. And so that is part of what people find out. I did want to comment about the medical history. Like if I only had a medical history of my birth mother when I was—
Hang on just a second, Senator Costa, if you want to hear this, go ahead, but no one's asked that question to her.
Okay, sorry.
Yeah, Chair, I am interested to hear about,
okay, go ahead.
In terms of that. If you can keep it short.
Thank you. Yeah, at the time I was born, my birth mother was totally healthy, but later, she had colon cancer. And if I only had a snapshot in time of a detailed medical history at the time of my conception, it wouldn't be that useful to identify my further risk in my life without having more possibilities of getting a more current medical history.
Yeah, thank you, Chair, because that was actually my initial question that was to the judiciary in terms of the medical, the important medical history. So thank you. I yield.
Thank you very much. Members, any other questions?
Chair, I just want to have a clarification, I guess, judiciary. So if this bill passes, any donor or person that is adopted will never be able to access these records. Is that what I'm hearing?
No,
Chair?
that's not what you're hearing, because the statutes for adoption will not be affected by this.
Okay, thank you. Just the people that donate.
Correct.
Okay.
Because we do not currently have any laws that regulate any assisted reproduction or surrogacy.
Thank
Okay.
you, Chair.
Thank
Thank you
you.
very much.
Other questions? If not, let's go ahead and move on. Thank you all the testifiers for being here. Let's move on to SB 2916. This prohibits the governor or the mayor from suspending requests for public records or vital statistics during a declared state of emergency. First up on SB 2916 is Ted Kafalis, Director, Strategic Campaigns for Grassroots Institute of Hawaii.
Aloha, Chair, Vice Chair, members of the committee. My name is Ted Kafalis with the Grassroot Institute, and we'd like to speak in support of SB 2916. While we understand that the executive needs certain leeway to handle an emergency, that should not give him or her the freedom to suspend laws just because they're inconvenient. Governors in other states were able to address the fact that resources were spread thin and there might be delays in responding to open record requests, but they didn't suspend the law outright. Not only did Governor Ige's actions raise questions about the rationale for the suspension, but it also undermined public trust at a time when that trust was needed now more than ever. Hawaii's open record laws are a foundation that promote an informed citizenry, which is necessary to ensure accountability in government. This bill makes it clear that the government's responsibility to the people does not take a hiatus during an emergency. I want to thank you for the opportunity to testify today.
Thank you. Thanks for being here. Next up is Department of Human Services with comments. Cheryl Kakazi, Park Director, Office of Information Practice with comments. R. Brian Black, Executive Director for Civil Beat Law Center for the Public Interest and Support. Sandy Ma, Executive Director for Common Cause Hawaii with comments. Lavana Loma, CEO and President for Our Rights and Support. Doug Meller, Legislative Committee for League of Women Voters of Hawaii in support. Leila Maurer, President for Kokua Council in support. Sterling Morita, President, Hawaii Chapter Society of Professional Journalists in support. Kimoona Kane in support. Dale Head in support. Nico Leverance in support. Rebecca Villages, Hawaii County Council in support. That's all the testimony we have on SB 2916. Members, any questions on this? Okay, I don't either. Members, I'm going to just take about a 3-minute recess. So come back in recess until 10:35. Okay, coming back out of recess for the Judiciary Committee for our 9:30 agenda, we are to Bill SB 2879. This requires certain landlords, lessors, or plaintiffs in a summary possession action to provide proof of payment of taxes due to the state as a condition of the issuance of a writ of possession. First up on SB 2879 is Tom Yamachika for the Tax Foundation of Hawaii.
Good morning, Chair, members of the committee. It's Jade McMillan again for Tom Yamachika and Tax Foundation of Hawaii. We will stand on our written comments submitted on this measure. Thank you.
Thank you. We also have Director Choi from the Department of Taxation with comments, and we have Ken Haraki for the Realtors in opposition. That's all the testimony we have on SB 2879. Members, any questions? Okay, let's see here. Okay, do either. Let's thank you very much. Let's go ahead on to SB 166. This is one where we posted a proposed SD1. This prohibits foreign nationals and foreign corporations from making independent expenditures. First up on SB 166 is Sandy Ma, Executive Director for Common Cause. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. Common Cause Hawaii appreciates the intent of proposed SD1 to SB 166. We understand the need for a strong campaign finance law that prohibits foreign interference in our elections, which is the foundation of our democracy. While we understand the need for a strong law, we are concerned with SB 166 proposed SD1. We think this is a great start. There are necessary refinements that need to be made to this bill, especially in the areas of the foreign ownership threshold. We have a little questions concerning the certification provisions that were changed in this proposed SD1, and there's some more changes in the proposed SD1 that we are still reviewing. But otherwise, this is a great start to this foreign influence bill strengthening. And thank you for allowing us to testify on this bill. Thank you. And I'm available for any questions. Thank you.
Great, thank you. Next is Gary Kam for Campaign Spending Commission.
Good morning, Chair, Vice Chair, members of the committee. The Commission appreciates the intent of this bill and submitted comments. I would just like to emphasize the point that if a super PAC cannot get a certification from its top contributor, then the Commission would prefer that that contribution be returned rather than that statement that in the ad that there may have been foreign monies paying for the ad. I think that's just going to generate investigations which may not be founded. Thank you.
Thank you. Next up is, I'm sorry, I'm going to butcher your name, Ron Fine or Fiend for Free Speech for People.
Thank you, Chair and Vice Chair and members of the committee. I am Ron Fine. I'm the legal director of Free Speech for People, and want to speak in qualified support of SD1 to SB 166. The one change that we think is really important is to restore the thresholds for defining a foreign influenced corporation that were in the original SB 166. That's if a corporation has 1% foreign ownership by any single foreign investor, or 5% aggregate foreign investment. And the reason for this is it's a little counterintuitive, especially if you're used to thinking of elections where 1% doesn't seem like very much, but in a major corporation, 1% is tremendously influential. A 1% investor can get the CEO of a major corporation on the phone within 24 hours. And in fact, it used to be a requirement at the Securities Exchange Commission that if somebody wanted to put a shareholder resolution on the ballot for a publicly traded corporation, they needed 1% of stock. And then everyone agreed. And when I say everyone, I mean the Business Roundtable and the AFL-CIO. You rarely see them agreeing on something. Everyone agreed that that threshold was actually too high because anyone that owns 1% of stock doesn't need to put a shareholder resolution. They're already influential in corporate governance. So this would also bring it into alignment with the legislation that Seattle passed in 2020 and with parallel legislation in the US House and that just passed the New York State Senate. And so the 5% aggregate threshold also, that represents a point at which collectively, as the CEO of ExxonMobil once said at a certain point, he said, "I'm not a US company and I don't make decisions based on what's best for the United States." So that's the major change we would request, the return to the 1%, 5%. Thank you, and I'll be available if anyone has any further questions.
Great, thank you. Next is Michael Sozan for testifying for Center for American Progress with comments, Nikos Leverance in support, and Jason Corta in support. That's all the testimony we have on SB 166. Members, questions? I do have a question for Mr. Fine. So the 1%, I understand the significance of owning 1% of a corporation, especially a big one. But how, as an enforcement question, how would you know that they own 1%?
That's a great question, Chair. So the answer is it's hard on the outside to know for sure the ownership of investment. There are sources of information that use non-public data, like CNBC has a site where it uses private data to get that. But the corporation itself can find out to a certainty. And this is something that they do all the time. Like every time they have a shareholder meeting, they have to find out who all the shareholders are. If there's like a merger, various other circumstances, they use services that can tell them who all of their stockholders are. So when the corporation is ready to make an expenditure or a contribution, they would engage one of these services and identify all of their shareholders. And then that's why the bill has this provision for a statement of certification where the CEO says under penalty of perjury on the date this expenditure was made, it did not, trigger those 1% thresholds. And then that penalty of perjury certification by the CEO provides the basis for enforcement. In other words, not asking the Campaign Spending Commission to try to find out who all the stockholders are of a corporation.
So, but in terms of publicly available records, I mean, I think my recollection is that the SEC, and this is why we put 5% in, my understanding is SEC requires that you report if you own more than 5%. So isn't that a lot simpler way for, I'll ask Mr. Cam presently the same question, but isn't that a lot simpler way from an enforcement perspective?
Well, like I said, it is true that 5% is the point at which somebody has to report to the SEC. A corporation has to report to the SEC the acquisition of stock. The 1% level, like I said, is you can find it out by looking it up on sources like MSN Finance or CNBC. But again, the corporation knows at all times. So by putting the burden on the corporation, that makes it much easier for external enforcement because like many things in campaign finance, you rely on a certification by a filer that they're telling the truth. And if they don't, then you've got a trial for perjury. But that's easier than asking campaign spending commission staff to be trolling through SEC filings.
Okay. All right. Thank you. Mr. Cam, the enforcement question, does the structure that Mr. Fine is suggesting work from your perspective as the enforcer for the campaign spending laws?
Well, clearly, the best scenario is if the information is available publicly, readily available. That would certainly make enforcement easier. But as I understand the testimony from Mr. Fine is that the corporations now are going to have to certify whether or not they are they were not a foreign influence corporation. There might be other remedies that they don't, if they falsely say that. I mean, it could be a referral for prosecution, but I guess that could work also. But then if you are looking at something that is initiated by the commission, then certainly if that 5% is the point at which that information is publicly available with the SEC, then we would prefer that level of ownership.
Okay, members, any other questions? All right, thank you all for being here for testifying. That ends our 9:30 agenda, so I'll recess that agenda and we'll go to the 9:31 agenda. There's only one bill on the 9:31 agenda, that is SB 2044. This increases from $1,000 to $5,000 fine that may be assessed for campaign spending law violations against a non-candidate committee making only independent expenditures and it has received at least one contribution of more than 10,000 or spent more than 10,000 in an election period. First testifier on SB 2044 is Sandy Ma for Common Cause. Good morning again.
Good morning again, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. Common Cause Hawaii supports SB 2044 that will raise the fines against super PACs. Thank you for hearing this measure, and I'm available for any questions. Thank you.
Thank you. Next up is Gary Cam for Campaign Spending Commission.
Good morning, Chair, Vice Chair, members of the committee. I will stand on the Commission's written testimony in support of this measure. Thank you.
Okay. Thank you. Next is Becky Shapiro for League of Women Voters Hawaii. In support. Next is Lynn Matisow in support. That's all the testifiers we have on SB 2044. Members, any questions? Okay, I don't have any either. That concludes the hearing portion of our agendas. Let's see, do we have quorum? 1, 2, 3, 4, 5. Yeah. Unless members feel the need to go into breakout room, I'm ready to start making recommendations. Okay, I don't see any objections. So let's go back to the top of the 9:30 agenda. First up is 2140 SB 2147. This relates to nomination papers. It extends by a month the deadline by which nomination papers for candidates for elected officers will be made available, but that's only for this year. Elections office testimony was that we probably don't need this, but I'm not quite convinced there aren't going to be any lawsuits that are going to foul things up. So I'd like to keep the vehicle alive, and we'll just put a bad date on it, July 30, 2075. Questions or concerns on this measure? SB 2147. If not, Senator Keola Kalole for the vote.
Members voting on SB 2147, the chair's recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Aye.
Chair recommendation adopted.
Thank you very much, members. Next is SB 2300. This allows candidates seeking election, both male or female, to use campaign funds for child care and vital household dependent care costs under certain conditions. Recommendation is to pass as is. Questions or concerns? If not, Vice Chair.
Members, SB 2300 passing unamended with all members present. Are there any reservations or no votes? Chair recommendation adopted.
Thank you. Next up is SB 2331. This expands the definition of beer to specify an alcohol by volume of no less than 0.5% and to include alcohol seltzer beverages. Recommendation here is also to pass unamended. Questions or concerns? If not, Vice Chair.
Members, SB 2331 passing unamended. Again, noting the presence of all members of the committee. Are there any noes or reservations? Seeing none, chair, recommendation adopted.
Thank you very much. Next up is SB 2082. This adds abuse of a family or household member to those felonies that qualify for repeat offender sentencing. Yeah, I'm surprised we've never done this before. So recommendation is to pass as is. Questions or concerns? If not, Vice Chair.
Members, SB 2082 passing unamended. Are there any noes or reservations? Chair, all members vote aye. Recommendation adopted.
Thank you, members. Next up is SB 2094. This would make it so that prohibition against individuals possessing or owning firearms to include right now, there's a distinction made between how you are charged for the crime. So this would just say that if no matter how you're charged for the crime that disqualifies you, that you'd be disqualified. So recommendation here is to pass as is. Questions or concerns?
Chair, what was that? You said any crimes or just felony crimes?
No, any of the crime. There are a few, as I recall, a few crimes that you can lose your gun for, even if it's a misdemeanor, I think. So that's why I said that, but it's primarily felonies. But we're not changing it. We're not changing the list. We're just saying that it doesn't matter how you're charged. It's information charging, you're indicted, whatever. It's just how you're charged. Okay. Any other concerns? If not, Senator Kalole.
Members, SB 2094 passing unamended. Are there any reservations? Any no reservations for Senator Favela? Any other reservations or no's? Chair, recommendation adopted.
Okay, thank you. Next is SB 2642, establishes an exemption from mediation and paternity proceedings where there are allegations of domestic abuse, and amends the exemption for mediation and divorce proceedings by disallowing mediation when there are allegations of domestic abuse. Members, on this one, I would like to move it forward. I would like to accept the amendments suggested by the judiciary, which essentially will make right now, paternity proceedings are treated differently than divorce proceedings. And I think that probably makes sense to treat them all the same. However, this would not, say this in the right way, this would change the thrust of the bill somewhat, because the bill currently says basically no mediation period. This would allow for mediation in certain circumstances. I don't think it makes sense to just completely eliminate the possibility of mediation. So I'd like to accept the judiciary's proposed amendments, and we'll move it on and see how that debate goes. Let me just be sure I don't have any other changes here. Oh yeah, let's go ahead and put a bad date on it too. July 30, 2075. Okay. Questions or concerns? If not, Senator Kalole.
Members, voting on SB 2642, the recommendation is to pass with amendments. Again, noting the presence of all members of the committee, are there any reservations or no votes? Chair, recommendation adopted.
Thank you, members. Next up is SB 2660. This allows defendants who entered deferred acceptance of nolo contender pleas to have the conviction vacated if conditions are met. And yeah, that's the thrust of it. This is kind of a tricky one because I think what the proponents are asking for is something that I'm not sure whether we can give it. So the recommendation is to pass with an amendment, with amendments to try to make it so that the plea itself, the plea of nolo contender or deferred acceptance of guilty, can be expunged or vacated. I guess it's really vacated, so vacated. And I will go ahead and put a bad date on it to July 30, 2075. But that would be the amendment. So there'll be some other changes that the idea of vacating something where you were never convicted doesn't really make any sense. So we would be removing that language as well. So I guess I would just add there would be text to conform to the attempt to make it so that vacated pleas can be, the pleas themselves can be vacated. And I will put it, did I say that already? Well, put a bad date on it to July 30, 2075. We'll take it forward. Questions or concerns? If not, Vice Chair.
Members voting on SB 2660, the recommendation is to pass with amendments. Are there any reservations or no votes? Chair, recommendation adopted.
Thank you very much. Next up is SB 2687. Specifies under the Hawaii Rules of Evidence that a court may order that the testimony of a witness be taken through a live two-way video connection in certain circumstances. I've supported this bill for a while, for years. I just don't really see a way to get there, so I'm going to defer it indefinitely. It's maybe the technology changes, or maybe the U.S. Supreme Court decisions change that make it easier, but for the moment, I think it's not doable. So deferred indefinitely. Next one is SB 2741 relating to the Commission to Promote Uniform Legislation. This provides a limited exemption so that the Hawaii members can participate in the Uniform Law Commission. I think this is, I hear the slippery slope arguments. I don't think that this will be the slippery slope because it's a very unusual situation. And for our members to fully participate, this will make it much easier to do that. So recommendation is as is. Questions or concerns? If not, Vice Chair.
Members voting on SB 2741, the recommendation is to pass this measure unamended. Members, are there any reservations or no votes?
Reservations.
So noted. Otherwise, Chair, all other members vote aye. Recommendation adopted.
Thank you, members. Next up is SB 2747. This is relating to the Uniform Parentage Act. This bill is unfortunately another victim of the pandemic. The task force report left a lot of unanswered questions, and I think a lot of that had to do with the fact that they just couldn't meet very many times. So what I'm going to suggest is that we extend their life and hopefully have some of these thorny questions worked out better before the legislation is passed. So I'd like to remove the language enacting the Uniform Parentage Act of 2017 and remove the repeal of the state's existing parentage laws. Insert language to amend Act 201 from the 2021 session to extend the Parentage Law Task Force until the end of this year. Require the task force to submit a report to the legislature 40 days prior to its convening in 2023, and will elevate the Department of the Attorney General to be a joint convener and co-chair of the task force along with the Department of Health. I'll make the bill effective upon approval. There'll be text as well. So hopefully they can come up with more definitive answers, but there were a lot of unanswered questions. Questions or concerns on that course of action? If not, Vice Chair.
Members voting on SB 2747, the recommendation is to pass with amendments. Are there any reservations or no votes? Chair, recommendation adopted.
Okay, thank you, members. Moving on to SB 2916. This prohibits the governor or the mayor from suspending requests for public records on vital statistics during a declared state of emergency. Recommendation here is to pass it with some amendments. I'd like to include a provision that indicates that the agencies cannot reject at any time, emergency or not, requests made to them. But then I would like to amend it, further amend it, so that the governor cannot suspend response deadlines for requests, but with the proviso that reasonable delays due to extenuating circumstances are acceptable. And then we'll also make technical and conforming amendments, including amending the subsection for the mayor's power that the bill currently overlooks. So the idea will be that the agencies will always have to take the requests, but depending on the circumstances, they may be able to delay the response because of extenuating circumstances. Questions or concerns? If not, Vice Chair.
Members, SB 2916 passing with amendments. Are there any reservations or no votes? Seeing none, recommendation adopted.
Thank you, members. Next up is SB 2879. This requires landlords, lessors, or plaintiffs in a summary possession action to provide proof of payment of taxes due. Well, I like the idea. I think that the testimony raises some concerns that I don't know how to address at this point, so I'm going to defer it indefinitely. Next up and last, I believe, on this agenda is SB 166 relating to campaign finance. This is the one that prohibits foreign nationals and foreign corporations from making independent expenditures. So let's go. My recommendation is to go ahead and adopt the proposed SD1. And instead of applying to all corporations, apply it only to corporations that contribute or make an expenditure of more than $1,000 in an election cycle. And also on page 12, line 4 to 7, delete the advertisement shall include the following statement. Some of the funds used to pay for this message may have been provided by foreign influence corporations, and replace it with if the funds have been provided by, or if they don't know, then the non-candidate committee shall return the contributor to the top contributor. And I'll go ahead and put a bad date on it to July 30, 2075. I'm not complete. I understand the arguments made by Mr. Fine, and but I think at this point, this will be easier to enforce for the Campaign Spending Commission. Questions or concerns? If not, Vice Chair.
Members, voting on SB 166 SD1, the recommendation is to pass with amendments. Noting again the presence of all members of the committee, are there any reservations or no votes? Chair, recommendation adopted.
Thank you. That concludes the 9:30 agenda. So we will adjourn the 9:30 agenda, and then we'll go into the 9:31 agenda for decision making. The only item on that agenda is SB 2044. This increases from $1,000 to $5,000 the fine that may be assessed for campaign spending law violations against the non-candidate committee, and does some other things that are similar. Recommendation here is to pass as is. Questions or concerns? If not, Senator Keokalole.
Voting on SB 2044, the recommendation is to pass this measure unamended. Members, are there any reservations or no votes? Seeing none, all members vote aye. Recommendation adopted.
Okay, thank you very much. That adjourns the 9:31. Don't forget, members, we do have a joint this afternoon. Now I can't remember what time. Staff, what time is the one this afternoon?
3 p.m.
3 p.m. joint with GBO and Ways and Means. Okay, thank you. Thanks for being here. See you soon.